Hi, I'm Michael Appel from BizNews.com. The Supreme Court of Appeal has today, the 21st of November, dismissed an application seeking to overturn a ruling of the High Court in Pretoria that the granting of Jacob Zuma's medical parole was illegal, unconstitutional, and invalid. A man who was in the Supreme Court of Appeal when arguments were made is Gabriel Crouse. He's head of campaigns at the Institute of Race Relations, an entity that was an amicus, that's a friend of the court in this medical parole matter, alongside applicants like the DA, the Helen Suzman Foundation, etc. Gabriel, thanks for your time.
Thank you, Michael. Good to be with you.
Let's start with what everybody wants to know. The appeal has been set aside, that we now know. Is Jacob Zuma ordered to go back to Escort Correctional Facility?
Unequivocally, yes. The Supreme Court of Appeal has ordered that Jacob Zuma must go back to jail in escort to prison. This has been misreported or confusingly reported. I've just done a little mainstream media work myself on that point. However, here's the fly in the ointment. The substance of this issue is that Zuma was released on medical parole by the Department of Correctional Services, by Arthur Fraser. That decision was unlawful. It wasn't just unlawful, it was kind of crazy because the Medical Parole Board had said Zuma doesn't deserve medical parole. And then the commissioner, who has no medical expertise, said, well, I know better. Let this guy off. So that's why it needs to be set aside. He needs to go back to prison. But then there's the question of remedy, because as everyone knows, Zuma's people have been arguing that he only had a 15-month sentence. It's been more than 15 months since that sentence began. October, I think, is the period at which it lapsed. So they say, look, he was released unlawfully, but he served his time under medical parole, and so it's time served. He shouldn't really be going back to jail. If he goes back, I suppose they'd say he should just go back for a moment rather than to do another 13 months because he only served 2 months inside. So that's the sort of argument that's being made. And the court observed that the Department of Correctional Services has actually already issued a media statement before the judgment came out, saying that they consider Zuma's time to be served. So on the department's version, Zuma doesn't really need to go back to court, to prison, because his time's been served. But the court has said, no matter what they've said, and the court complains about it, they say this is, it was incorrect for them to make a media statement so early, and this shouldn't be read as conflicting with the order. Very straightforwardly, the court says this guy has to go to prison. But they then say, well, how long he should stay there for is going to be up to the department to decide.
Yes, and that's an issue we'll get into. I just want to touch on that point, and I'm going to read verbatim what the judgment says around the fact that the department jumped the gun. They didn't wait for the SCA to make a ruling on whether or not that medical parole was, a second court was lawful or not. And it says, I feel constrained to express this court's disquiet about one aspect. While this judgment was pending, we became aware that the Department of Correctional Services released a media statement to the effect that Mr. Zuma had completed his sentence. Such a pronouncement was premature, given that the determination of the very issue was still pending before this court. A decision as to whether Mr. Zuma's prison term had lawfully expired could not be validly made until this court had determined the appeal by the commissioner and Mr. Zuma. This court has now determined that Mr. Zuma's release on medical parole was unlawful. The department's statement was unfortunate and undermines the judicial process. Clearly, pretty upset that they got undermined in that way.
And so they should be. It was an obvious abuse for the department to go ahead and say Zuma already qualifies as time served. But here's my worry. On the one hand, the SCA slaps the department on the wrists and says, bad behavior. You shouldn't have released that press statement. On the other hand, the SCA says, look, there's this very difficult question. Should Zuma's unlawful medical parole time count as time served or not? Does it count as time served because medical parole is a way of serving time, or should it not count because it is unlawful? Well, we're not going to answer that question. We're going to defer to the executive, and in this case specifically the Department of Correctional Services, on how to resolve that. Now, I'm not a lawyer, Michael, and we haven't discussed this with our lawyers fully yet, but that sounds exactly to me like saying this. The department made a boo boo, department did the wrong thing, and now it's got to decide what the punishment should be. It's got to decide what the remedy should be. That seems crazy to me. If the very same department unlawfully released Zuma, how can that department be relied upon to decide whether the unlawfulness should count for anything or should merely be ignored? Obviously, it's in the department's interests to ignore the unlawfulness of it. Uh, it's the one that made the wrong move in the first place. So, by analogy, it's like as if the Concourt had said to Jacob Zuma, look, we've ordered you to go to the Zondo Commission and you didn't do that. You broke the law. Okay, you decide how you're going to fix the problem. You can't do that. I mean, that's what the SCA seems to have done. So, yes, I'm very glad you read out that quote, and it shows that the SCA is willing to, in a polite and constrained way, criticize the department. But I'm afraid that I suspect, just in layman's terms, that it hasn't really stuck to its guns in terms of acknowledging that once you realize the department unlawfully released the guy, you can't leave it up to the department to then decide how to resolve the issue.
So the court, to my mind, is relying on separation of powers doctrine here, and it says as much in the judgment. So the High Court, the court of first instance, the quarter quo, says that in paragraph 5, which importantly has been set aside by this SCA judgment, says any time spent outside of court should not count towards Jacob Zuma's overall sentence. Now that has been set aside. They then say, in terms of the separation of powers doctrine, they as the court are not going to they're not going to throw it back to the High Court, and they, as the SCA, are not going to make a judgment call on what time should be considered towards his overall sentence. And as you say, they are now going to send it back to the very people who made a boo-boo in the first place to say to this new acting commissioner, a guy who took over on the 27th of September, just after Arthur Fraser left, there's a new acting commissioner. As I understand it, it now falls on his shoulders to decide probably one of the most pressured decisions in the history of government. Are you going to consider Jacob Zuma's time on medical parole towards his general sentence? Is my understanding correct?
That's absolutely right. And I'm unfortunate, I must say, the new commissioner's name escapes me. I've been more focused on the new police commissioner, whom I saw well excoriated by Paul O'Sullivan and Alec Hogg on BizNews. But yeah, no, the pressures is going to be tremendous on him. It's hard to expect, based on previous Ramaphosa appointees, sort of elevated acting commissioners and department heads and so on, that he's going to do anything other than what suits the ANC best, which is to leave Zuma in Nkandla to do as he pleases and to champion the party when it suits them. I would be delightfully surprised if it goes otherwise. But I just want to say on the deference to the executive on the basis of the separation of powers, this argument that you noted, of course it's the case that generally speaking, the courts try to stay out of the hair of government departments. That kind of deference is really important, and I don't want to devalue separation of powers. However, it's clearly the case in this instance that the court has not shown deference to the executive. The executive said we want to release Zuma on parole. We did release Zuma on parole, and the court said, no, guys, that was the wrong thing to do. That was unlawful. Zuma's got to go back to jail. Once you've made that judgment, I think the horse is bolted in terms of deference to the executive. And I think it's sort of strange to say, look, you've clearly, in this particular case, made an unlawful decision. But in this particular case, we're going to defer to you on the remedy. And if you look at PAJA, South Africa's law on administrative justice, and if you look at our founding values, I don't think you're going to find a principle of deference such that the court can find the executive guilty of unlawful conduct, but then must defer to the executive on how to remedy that. No, once a guilty finding has been made, the court is then in the position to dictate the remedy. And it's a requirement of the court to dictate the remedy. On that basis, more legally, I think that I question the SCA's judgment, but we'll also be looking into it further.
So the hypothetical realm here is that the decision now goes back to Commissioner Tabokhale, is his name. And he then goes and looks at the 15 months. And this is something we discussed off air. He looks at the 15-month sentence. And I mean, there's a plethora of voices out there who say you must only serve a certain amount, 2/3, a third, half, or he must serve 15 months to be eligible for parole. Now, the IRR's argument, and I'll give you an opportunity to say what that was, but the commissioner can look at the time served and go, yes, I'll count it towards, or I won't. Now, it all comes down to what the court ruled, and that is that it is not a special category of contempt of court is not a special category offender. Now, take it away. How did the IRR see this in the SCA and try to argue it? And the point must be made, your argument wasn't accepted, but what was it?
Great. Yes. The SCA considered the IRR. We came in pretty late. We came in as an amicus, and the court considered our views at some length in the judgment and rejects our view. Here's the substance of our view, and here's why it's relevant to the commissioner's considerations. Our view was that in South Africa, there are three kinds of sentence. A court can make an order that you're guilty and you have to pay or go to jail or something according to three categories. One is civil offense, one is criminal offense, and the third is contempt in a sui generis fashion. It means a Latin term for a category of its own kind. So in civil cases, you sue someone else, your neighbor, their dog was barking too loudly, it gave you a headache, whatever. You shot the dog. They say that's terrible. No, I suppose that could be criminal. No one hurts anything, but there's some kind of damages done. The importance about civil procedures is that there's a different burden of proof. There's a different appeals process. Generally speaking, the law is not protecting one side or the other all that much. It's kind of leaving it out to you to box each other out. And almost never is anyone going to jail. In the second instance, you've got criminal proceedings, where standardly, if someone's found guilty, they're going to go to jail. And standardly, you've got the NPA, you've got the government going after someone. And so the law in that situation is designed to protect the accused. And people, this is like a common talking point at the petrol station. Everyone knows, South African law protects the criminals much more than the victims. That sounds terrible, but it's often misapplied. But there's a good reason for why there's a different standard of proof, a different requirement for appeal, and so on for criminal cases. Now, contempt can't be the same as a criminal case. Why? Because in a contempt case, the court is accusing you of a crime. We ordered you to do this and you refused our order. Or you came into our building and you were swearing at us and pulling your pants down, you were insulting us. The court is the complainant and the court is also the judge. And the principle of the rule of law says inter alia, thou shalt not be a judge in thy own complaint, So it's a problem, but how do you deal with this problem? If it meant that people could just swear in court and disrupt it, or could refuse to come forward to give evidence when ordered, because they're going to be tried for contempt by the court, where else can it be tried? They could just get off scot-free. In contempt cases, there's a special problem with how the law needs to be set up. And that's because in a contempt case, the court is accusing you of a crime and the court is trying you for a crime. So it's saying you insulted us or you refused to obey our order. And we're the same entity that's going to then determine whether you're guilty or not. Now, the rule of law usually says that you can't have that. The rule of law says, thou shalt not be the judge in thy own complaint. And so it's like a big problem. How do you deal with people who are in contempt of court, who insult the court or refuse to obey its orders? One thing is you could just leave them out, let them off scot-free, because it's always going to be the court that has to deal with it. The same court, especially if it's a constitutional court order. Alternatively, and this is how the law is already established, you allow the court to find them guilty, but you limit the kinds of things that qualify as contempt to things where the evidence is uncontested and very open. So if someone insults the court in front of everyone else, there's going to be no evidentiary clash about whether they really did the insult. Or if the court issues an order, it's very clearly delivered. There's no evidentiary question. So it's not like a murder trial where the evidence issue is quite complicated. It's straightforward. In Zuma's case, it's straightforward. He was ordered to go to Zondo. He didn't go to Zondo. There's no doubt about that. So he couldn't complain that the court is not finding fairly the test of evidence. The second thing is, in terms of sentencing, that for contempt of court, courts are obliged, when they sentence an offender, to, as it were, keep that offender as their baby. So if they find him or her guilty of contempt for refusing an order, if he then obeys the order and says, okay, I want to go testify, the court has to reconsider the sentence. If he insulted the court and then says, look, I'm very sorry, I never should have been so disrespectful, I'll keep my pants on forever, I promise I'll never do that again, they must say, okay, well, we're going to reconsider your sentence. Usually, once you've been sentenced, if you murder someone and you get sentenced, that's it. You can't go back to the court and appeal your sentence. So that's a different set of rules for ordinary criminals to what it is for contempt cases. And Zuma was a contempt case. And from the beginning, he should have been treated that way. But the other complainants didn't look at South Africa's historic law, constitutional court judgments, laws under the Criminal Procedures Act, and neither did Zuma's side. And so he was kind of treated as an ordinary criminal when he wasn't. And the IRR came in to say, look, this guy's guilty of contempt. You've got to treat him according to the rules of this third category, which have been laid in place since Smuts de Lange, a Concord judgment from a couple of decades ago. And according to that, if Zuma wanted to get out, he must have gone back to the Constitutional Court and he must have given evidence to testify before Zondo or complain about a medical condition, whatever. He had to go back to the same court that sentenced him and nowhere else. And any time that he served outside of prison unlawfully as a result of a violation of that principle is not medical parole. He never was eligible for medical parole or parole for good behavior. There's no half the time served, now you're eligible for parole for good behavior or 2/3. That does not apply to him. That's for ordinary criminals. Zuma is not an ordinary criminal. He is a contemnor, and there is a law of contempt, and he must be treated according to that law. We've got nothing personally against Zuma. We just want the law, as it stands, to apply.
Okay. Now, we have to deal with the fact that this is likely to be appealed. We all know Jacob Zuma. There's 2 decades of litigation to suggest that he will litigate to death on this matter. And he will do anything to stay out of prison. And let me just read you what Mzwanele Manye, his foundation spokesperson, said. Quote, a smile of a free man. It's a picture of Jacob Zuma on his Twitter profile. He is not, in capitals, going back to prison. Now, is that contempt of court order number 2 loading here? Or is he going to take this to the Constitutional Court? There's one of 2 outcomes here.
Well, maybe more. So one way that this could go forward is that Zuma could say, look, I can read, and it clearly says in the SCA's court order that I have to go back to prison, even if it's only for long enough for them to let me go again. But I don't want to do that, so I want to appeal against the judgment on that basis. I don't think he's going to do that, and I'll tell you why. When you appeal a judgment, the rules about, which part of the order gets set aside and which part of the order holds force could count against him in this instance. Standardly, when you appeal, you go back to the status quo ex ante. In this case, that would mean he does get to stay away. But if it's the case that the court order can be satisfied without interrupting other aspects of the course of the appeal, then you don't get to apply that set-aside rule. And when you apply for appeal, you apply back to the same court. You'd have to apply to the SCA first. They might say, look, you granted the appeal, but we're going to specifically deny you the set-aside on this order. And that's a risk that you take. They might not do that, but it's the kind of thing that courts sometimes do. So sometimes if a court finds someone guilty of a violent offense, and then they want to appeal it to the SCA, for example, a high court finds you guilty of murder and rape, the court might say you're guilty, you're going to jail, and we're not going to release you while your appeal is going through because we think you are a danger to society. So he might instead try to just stay away, like last time, where the Concord specifically ordered, like, if you don't go to Zondo, then you must take yourself to prison, and if you don't go to prison, the police must pick you up. He might try and do the same thing he did then, which is just not to do anything and play a game of brinksmanship with the police to see if they're going to enforce this court's order. And in this case, in the last case, the police went to the Constitutional Court over the weekend, writing furious letters like, you guys have said we have to arrest him. Could you please clarify whether that means we have to arrest him? It was so bizarre. I think in that instance, there was clearly no ambiguity, but they still tried it. In this instance, you've got a lower court, SCA, not Concord, and you've got this ambiguity created by the fact that the lower court has already acknowledged the Department of Correctional Services press statement saying that he doesn't have to go back. So they could leverage that ambiguity to say, we really don't know if we're supposed to force him to go back to escort if the Department of Correctional Services says he doesn't have to. So in what I'm suggesting is there's a very muddy scenario where Zuma stays at Nkandla, does what he wants, and other people say, oh, we're too confused to know what to do, in which case, if there's going to be an appeal, it's going to have to be filed by the original appellants, the DA, AfriForum, Suzman Foundation, and perhaps this time the IRR as a direct respondent rather than as an amicus. And to try and say, look, Zuma should go back to jail. And there'll be two arguments. The one that I think we kind of all agree on, which is that since Zuma was unlawfully released, his unlawful parole can't count as time served, even if he was eligible for parole in terms of the jurisdiction. And then separate to that, and I think the best chance that South Africans have of vindicating the rule of law, sticking to principle, and putting Zuma behind bars where he deserves to be, until he testifies and gives evidence, if he so chooses. The IRR's argument that he was never eligible for parole, never mind the facts of his medical condition or whatever, he was never eligible in the first place because he was guilty of contempt, and that put him a special category. And on that category, there is absolutely no doubt that there is no deference to the Department of Correctional Services. There's no separation of powers issue because he wasn't the Correctional Service Department baby. He was the court's baby, and the court was leaving him in the custody of, the nanny, as it were, was the department, and they let him go when they weren't supposed to. Doesn't count as time served at all because legally, never mind on the fact, he didn't qualify for such time served. So that's part of the reason we're going to have to be digging into this to see if, as you said at the start, the SCA rejected our argument, but in so doing, I think they didn't just keep the door open for Zuma to stay out of jail, which is a problem in this instance. I think they clearly in paragraph 26 of the judgment, they just do away with the whole contempt third category. And they say everyone who's guilty of contempt is going to be treated the same way as an ordinary criminal, which I think is a nightmare. It goes against established law. And also it's a nightmare because it means that the special protection that you had when the court was both the judge and the jury and the executioner, as it were, in matters where it's also the complainant, the special protection that you had, which is you could always go back to the same court to appeal the sentence on the basis that you have remedied your contempt. They're taking that away. And so for ordinary people in insolvency, in tax law, there's all kinds of places where people are forced to come and produce evidence. And if they don't do it in time, courts find them guilty of contempt and can put them behind bars. I think with the land court bill coming along, the land court is something I really worry about. I don't want courts to have the power to say, we've got a beef with you, we're going to put you behind bars, and then we no longer have to deal with you if you're trying to redeem your contempt with contrition. You're going to then be stuck with the Department of Correctional Services, which can have its own standards. And there the standards are usually that you have to serve something like half your time before you're eligible for parole and good behavior. Whereas with contempt, you're supposed to be eligible for getting out the next day once you change your ways. So the SCA, to my mind, has set a very, very dangerous precedent that goes beyond the Zuma case. But let's be honest, the Zuma case is the biggest, most high-profile criminal matter in the history of the new South Africa. And on that basis alone, I think there's a public interest in preserving the rules as they were established beforehand, and not rewriting them as we go along to try and fit maybe some other interest in keeping him out and avoiding a July riot or something like that.
Yeah. Okay. So everything you've spoken about in terms of how the court treats somebody guilty of contempt of court, that is something that could then either be dealt. It looks like it may land up in the Constitutional Court anyway, where that'll then be ventilated.
That's where it should have gone in the first place.
Hmm.
I think if there was, in a way, there was it from the very first moment that Zuma was let out, the matter should have been taken straight back to the Concourt. He's their baby. And I think that is going to be where this ends up one way or another.
Last question. And it's an issue, it's a consideration that came up in Arthur Fraser's own papers, to my recollection. And that is Jacob Zuma gets imprisoned, the country, all hell breaks loose. July riots 2021. Do you think Jacob Zuma is going to play chicken with July riots July riots version 2.0 as yet another consideration that some poor acting commissioner has to make, or Justice Minister Ronald Lamola has to go, okay, if we re-imprison this guy, re-incarcerate him, he is going to call on his RET forces, and ergo, they're going to use the threat of burning the country down based on a unlawful incarceration, going to jail without trial, as Mr. Manyi likes to put it. Do you think that they're going to hold this over this whole reincarceration issue?
Let me just quickly pick up on when you said Jimmy Manyi has this whole issue with Zuma went to jail without trial. That's because he was guilty of contempt of court, the special third category, right? So I think Jimmy Manyi was making the correct complaint to the DA and AfriForum and others, and to the SCA. You can't treat Jacob Zuma like you are guaranteed, if you're an ordinary criminal, the right to appeal, but you can't appeal a judgment at the Constitutional Court. So the IRR is the only, I think, institution that's like really taking seriously the fact that it doesn't get him off the hook that he went to jail without a trial, because we've already established contempt. You don't need a trial. You have a different procedure, and there it goes. Anyway, so we can meet Jimmy Manyi with argument rather than just trying to talk over him, which I think is what other parties have in a way been forced to do. But in terms of the crisis that might unfurl if we put Zuma back behind bars lawfully and properly, that is nothing compared to the crisis of if we let him go scot-free on the basis that we're afraid of what happens if you uphold the rule of law. Tyranny equals the veneer of democracy plus the fear of terrorism driving you away from the rule of law. Tyranny is what happens when you bow down before terrorists. If Jacob, the argument for leaving Jacob Zuma out of jail because we're afraid of another July riots is the argument to live under the boot of tyranny. I refuse to stand by and let South Africa become a place where the rules apply to you and you and you if you're an ordinary citizen, but if you're a really big macho, you can do whatever you like. The highest court in the land can order you to give evidence on state capture, which has cost us, de minimis, at least 1.5 trillion rand. Let's say at least, you don't have to give the evidence. You don't have to obey the court's order. You don't have to, have a lawful reason to get medical parole. You can just have your buddy say it's okay. And then when you get out, you don't have to go back to jail because people are afraid. If Ronald Lamola wants to do his job, that should mean that he is preparing for that situation where people try to stoke up fear and loathing in order to violate the rule of law. And Lamola should be making sure that it's blocked, that there are intelligent spies, basically, that are infiltrating these groups so that the moment they start trying to activate, the police know where they are and arrests can be made. The moment before the insurrection actually manages to light the match, while they're going to the matchbox store to get the matches, you've already caught them. Obviously, you have to wait for them to do a crime. I'm not suggesting thought crimes, but you've got to be prepared. You've got to be prepared. I have been to criminal trials in Newcastle, in Piet Retief, Mkondo, in Senekal. Senekal was a very nice example to me. The police are not popular in this country, but I celebrated the police after the Senekal affair because there were thousands of EFF supporters, over 10,000 bussed in there. There were some, I think, sober-minded people trying to argue against farm murders. There were definitely some rabble-rousers on the other side too. And there were open calls for bloodshed. But no one was killed, nothing but a couple of, thrown rocks and fists really occurred there. And the reason for that was tremendous police preparation, barbed wire fencing, helicopters in the skies, fixed wings circling overhead, command and control, diffusion from the night before, checking every vehicle for firearms coming in. They took a very hot moment, a moment that Clement Motlanthe described as a potential civil war, and the police, through hard work and preparation, made sure that they diffused and de-escalated the tension insofar as was possible. The police can do it. At least they can do it at that scale. They need to get ready to do it at a much larger scale if need be. I think that the answer to lawlessness, to terrorism, to violent threats trying to circumvent our constitutional order is proper, disciplined police work, investigative work, command and control. And given the limitations of their capacity and the massive numbers of private security agents and people with expertise, I think the police should be soliciting advice and help where they can from bona fide members of the private sector that are keen to uphold law and order in this country. There was bloodshed. There was the struggle, the People's War. Anthea Jeffrey writes about, my colleague Dr. Anthea Jeffrey at the IRR. At least 25,000 people were killed between 1986 and 1994. We didn't exactly have a bloodless revolution. There's a lot that went into getting South Africa to be a constitutional democracy, and it cannot be thrown away because we're too afraid to put a contempt law, an obvious violator of the law, behind bars, or because our police minister and commissioner are too useless to be able to, anticipate a riot that's being advertised on Facebook and Twitter. It's like not taking anyone by surprise. So I think that we should be able to properly address it and vindicate this constitutional project. It's an indispensable option. And if you don't do it, I'll just say one last thing. If you don't do it, and you think that you as a South African are going to get predictable, easygoing, free and fair elections, that you are going to get increased transparency in the civil service, that procurement, the R1 trillion the government spends every year, is going to stop going to crooks and start going to good guys. We're going to let Zuma off, even though it's obviously the law requires him to go back to jail, because we're afraid. But everyone else is going to start going in line. Everyone else is going to start acting properly. I think you should consult the history of fragile democracies in South America, across Africa, across Southeast Asia. And I think the lesson that you're going to come away with is that every single time citizens bow down out of fear to some former president, they set themselves up for much greater challenges going forward.
Well, I don't think there should be any surprise here. Jacob Zuma is telling us what he's going to do. He is not going back to prison, and I think South Africa and its authorities should be ready for the consequences that flow from that. Gabriel Crouse, it's been a pleasure chatting to you. Thank you.
Thanks.